Hello, Spencer. This is Alex Stepien, podcast producer and host for Trademarkia, and welcome to our podcast.
Hi, thanks for having me.
It's a pleasure. So, tell us a bit about yourself.
So I'm a registered patent attorney. I also practice a little bit of trademark, copyright, and litigation. And so I live in Arizona. I went to Texas A&M University for law school, and I just love working with patents. I've done it for several years now, and it's just always been one of my passions.
All right. So, Spencer, what exactly is a patent?
So a patent is a piece of intellectual property that grants the owner the exclusive right to make or produce something for a term of usually 20 years, 15 years if it's a design patent.
All right. And where does this type of law find application in what domains of business and life?
So there's many applications for patents. Right now, of course, we're in a big tech AI boom, but it can be for anything. It can be for a new, useful, non-obvious composition of matter, uh, process, a method of manufacturing. There's many different realms where patents apply. For example, there's patents in many things that we use. There's tons of patents in our smartphones. There's tons of patents for software, for Zoom that we're recording on right now. There's patent protection everywhere you look, and it's what helps drive the competitive aspects of our free markets across the world.
What qualifies as a patentable invention?
Yeah, so like I mentioned earlier, a patentable invention would be a new, useful, non-obvious, non-abstract method of manufacture, process, composition of matter, along those lines. And so by new and useful, it has to be something that has not been done before, obviously. That's kind of the backbone of patents, but it has to be useful as well. It has to be something that can be done. So for example, you can't get a patent for something that's like a time machine or perpetual motion machine or perpetual energy machine, because those things right now have been proven to be impossible to make. So it has to be useful. And another realm of usefulness as well would be if you invented something that would apply to very, very old technology and doesn't make it better. So if I invented a new flip phone that uses analog technology, I wouldn't be able to get a patent for that because it's not useful. It's not something that helps drive competitive spirit. It doesn't help drive innovation.
All right. All right. Uh, how does someone know if they need a patent for their invention to sell it?
So you really want to think about a few things. First, is it new? Is it something that is new? Is it something that would qualify for a patent? The next step would be, is there market value there? Patents can be very expensive, but you want to make sure that you have market value. With that being said, patents can offer a lot of value just by owning the patent. So if you have a business and you decide to patent something that your business is making or you're thinking about making, having that patent can add value to your business. It shows that you mean business, as in you're willing to invest in your business. And so investors, potential buyers down the road may see that and value your business in a better manner. It also can help you block others from manufacturing or doing what you're doing. And so, if you want to have that exclusivity in your business and you think that that's something that could be valuable, then that's when you want to start considering procuring a patent.
All right. Next question in that case. How long does the patent application process take?
So typically the patent application process for your normal utility patent, your 20-year lifespan patent, it's going to take about 18 to 24 months, if not longer. The patent office is very slow in what they do. It's literally a line system. You file your application and you get in line. So we've seen it take 4, 5, 6 years, depending on how many refusals, aka office actions that you get from the patent office. So it can take a long time. But with that being said, there are fast track options. There's one option called Track One, where you can pay an extra fee to have your application bumped to the front of the line. And Track One applications are typically fully complete, start to finish, within a year. There's also application accelerations for applications based upon age. If you're 65 and older, you can have a faster examination time. If you are facing a health issue, oftentimes the patent office will accelerate your application. And recently, there has been an acceleration option for inventions that are considered environmentally friendly. So that could be like a biofuel or a motor that reduces combustion, electric motors. There's many things that can qualify for that environmental fast track option.
Interesting, interesting. But as a reminder to our viewers, we're talking about American law, the law of the United States of America, correct?
Correct. Yes. Yes. I'm licensed in the United States. I know that the process throughout the world can often be long, just like with the US, but I'm speaking from my US knowledge.
All right. Are you involved at times in patent applications extending patents to other countries, Canada, Mexico, or maybe Europe or otherwise?
So the most that I get involved with internationally would be PCT filings. And so PCT filing is essentially the first step to filing in multiple countries across the world outside of your home country. And so with the PCT application, you typically start with a national filing in your home country, usually. So I often deal with that in the United States. And then you file what's called a PCT application, and from there, that PCT application allows you easier access into foreign countries. So that's typically what I touch on internationally. I work closely with patent attorneys in different nations, but I'm unfortunately not licensed in anywhere other than the United States. So I don't do any of the direct legal work. I just kind of work hand in hand with international attorneys to facilitate international filings.
All right. How do you check if someone has already patented a similar invention?
So there's many routes. Of course, you can start with just your basic Google search, but there is other options on the web. Google has their own patent platform called Google Patents. There's also a website called eSpaceNet. That's more of an internationally based website, but that's also a great option to search for patents. I would recommend those two if you're just your average inventor, not a huge knowledge base of patent law. I would start with those two. Of course, it's always best to hire a professional to do a patent search for you. There's many nuances across the global patent platforms, global patent treaties. For example, there's a patent classification system that's used internationally by international bodies such as the EU, different countries, United States, Canada, Mexico, you name it. And so having a knowledge base of that patent classification system can greatly enhance the clarity and precision of a patent search, because knowing the classes can help you kind of pinpoint where to conduct your patent search.
Is it possible for malware or other types of nefarious agents to intercept a patent search query and move against it in some form of patent trolling?
So I suppose that that's entirely possible. I haven't dealt with that in my professional experience, but I think that that's entirely possible. Part of the art of that would be the part of the art to get around that would be to not necessarily disclose what your invention is, but kind of search generally in the field and see what you can find. But I think that that's something that probably is possible. I think that that kind of speaks to best practices as an inventor, having really good firewall and anti-malware software on your computer if you're going to be working with sensitive classified information. Having some of those protections, I think, would be very important as you take those steps to crafting your invention, searching for your invention, communicating with a patent agent or a patent attorney. Having those protections is very important.
How does a patent attorney help me file a patent?
Yeah, so patents are definitely some of the most complex legal documents you'll ever see. If you've ever read a patent, they're extremely verbose. They have a ton of legal jargon. And frankly, the way that patents are drafted is extremely archaic, in my opinion. But that's just the way that they have to be drafted. They have to be drafted in a certain form with certain requirements. And if you don't hire someone who knows exactly how to use patentable language, you could potentially A, waste a lot of time and money, and B, not get the protection that you may deserve for your invention. For instance, the claims on a patent are the legally protectable part of your invention. It's the most important part of the patent application. But if you don't know how to write them in the proper manner, they could get rejected, they could be overly narrow, or they could be written in a way that leaves it wide open to be designed around. And so, what I always like to tell my clients and people that I work with is that as the patent attorney, it's my job to take your invention and change it into patentable language. You, as the inventor, you're the expert of your invention. You know it best. No one knows your invention better than you. It's your baby. But I can take that and put it into patentable language and protect that baby for you and help you have an asset for that invention.
Great answer. What are the most common mistakes people make when filing a patent?
So I think some of the most common mistakes would be not fully disclosing everything that their invention does. It's happened, unfortunately, a couple of times where, you'll file a patent application and the inventor will turn around and say, "Oh, shoot, I forgot about this embodiment." And so when that happens, you'll have to file a continuation. And so, it's important that you fully disclose every single potential embodiment, part, feature, everything possible for your invention. The next thing that can be a potential problem is waiting too long to file that application. If you don't approach a patent attorney or you wait too long to file a provisional application, you may shoot yourself in the foot. You may open yourself up to someone else disclosing that very invention or filing for that invention. And so being prompt is very important. Um, and so, along those lines too, kind of the converse, disclosing your invention. Don't post your invention on Facebook. Don't tell people about it unless you've decided that you don't really want to protect it, because disclosing in any manner can really come back to haunt you.
I see. Do you recall any spectacular cases of worst case scenarios developing after people failed to do what you just recommended?
So I haven't seen it in private practice, but when I was providing preliminary opinions for PCT applications, there was quite a few times where in my research, I would find that this person disclosed their invention on Facebook over a year before they filed. I would find that they would disclose their invention, wait, maybe not past the bar date, which is a year after you disclose. If you disclose your invention, you have 1 year to file. But they would disclose it, and then someone else would file a patent. And so, although if they were to have filed that patent based upon the knowledge that they gained from that other party's Facebook post, you still have to prove that, and it causes a major headache. And so it can really, really come back to haunt you.
Would you say that the emergence of generative language models, some people call this AI, I wouldn't, that these new technologies make it easier to register patents, to research patents?
I think so. I think that they can help point you in the right direction for various patent laws. They can help proofread things. And so I think that, you know, for the average user and in practice, they can be very useful. Um, and so, you know, as a pro se filer, if you really wanted to, it's something that you can use, but keep in mind, these things aren't perfect at all. They're not trained patent specific, but I think that they can help point you in the right direction.
Protect your brand with Trademarkia. Register your trademark on trademarkia.com.